introductions, the high seas are a sort of long historical origins. It is originated from the doctrine of mare liberum. The high seas can be defined as all parts of the sea that are not included in the territorial sea or in the internal waters of a state. The high seas being open to all nations, which means that no state may validly purport to subject any part of them to its sovereignty. Freedom of the high seas is exercised under the conditions laid down by these articles and by the other rules of international law. It comprises inter alia both for coastal and non-coastal states. For example, freedom of navigation, freedom of fishing, freedom to lay submarine cables and pipeline, and freedom to fly over the high seas. This freedom and others which are recognized by the general principle of international law shall be exercised by all states with reasonable regard to the interests of other states in their exercise of the freedom of the high seas. However, human activities including vessel pollution, fishing, mining, geoengineering, and are rapidly affecting the high seas. One of the pollution is vessel pollution. Thus, Article 14 of UN clause lays down marine environmental pollution. Therefore, the state shall be implements laws and regulations to prevent contamination of the aquatic environment from or through the atmosphere.
MARPOL stands for International Convention for Prevention of Pollution from Ships, and it is one of the main key instruments when it comes to the topic of safety and environmental protection of the sea. It's the most important international convention that focuses on the issue of marine pollution. MARPOL has been originally signed on 17 February 1973 but has been officially come into force on 2nd October 1983 after revised in 1978 by the protocol. MARPOL basically contains 2 protocols and 6 annexes. Annex 1 of MARPOL basically contains the regulations for prevention of pollution by oil. Next, Annex 2 basically contains the regulations and guidelines regarding the control of pollution by noxious liquid substance in bulk. Annex 3, on the other hand, aims to prevent the pollution from harmful substance carried at sea in package form. Annex 4 contains the regulations to control pollution of the sea by sewage. Annex 5 is the regulations of disposal of garbage from ships. Annex 6 lastly regulates the prevention of air pollution by ships. Overall, we can see that the regulations that are set up in MARPOL are very important in preserving the sea. It is also very important in order to prevent the marine pollution from destroying the sea.
Most of the issue raised is to focus on the principle of the law of the sea and not on the protection of marine, which is then lead to the establishment of a principle in customary law, where no state has right to use or permit to use its territory and resorted to cause injury to other states. This principle is recognized under Article 194 Clause 2 of the UNCLOS. However, there are few disputes arise rather than came specific rules and regulations on marine pollution. As consequences, treaties regarding marine pollution was established by using 3 approaches. First, the source-specific approach, which aimed to seek regulation and control on specified sources or substances of marine pollution, which most of the global convention adopted this approach. Example is MARPOL. Second, the regional approach, which aimed to regulate marine pollution in a particular region. Third, the regional source-specific approach, which combined both earlier approaches. And after that, protection and prevention of the marine environment finally established under United Nations Convention Law of the Sea. Generally, all states are obligated to prevent any marine pollution as stated in Article 192 of the Convention. Thus, UNCLOS also covers most of the marine pollution, as in Article 194 Clause 1 of the UNCLOS, where states are obliged to take all necessary acts to prevent any marine pollution. And Article 194 Clause 3 deals with all sources of the marine environment's pollution. Based on these articles, we knew that United Nations Convention Law of the Sea focuses on regulation in preventing marine pollution and not only on its responsibility. Thus, according to Article 211 Clause 2 of the UNCLOS means that flag state regulation of vessel pollution must have the same effects and be accepted in other international rules and standards. Besides, it is hard for a country to prevent pollution, so the establishment of international cooperation made things easier, which is laid down in the case of MOS plan case, which is consistent with Article 197 of the UNCLOS for the protection and preservation of the marine environment. In addition, if any marine pollution occurs, states are obliged to notify other states regarding the danger as accordance to Article 198 of the UNCLOS. States also have responsibilities and liabilities concerning the protecting and preserving the marine environment, which can be seen in Article 235 of the Convention. In conclusion, it can be said that UNCLOS does provide the regulation regarding marine pollution.
Next, we go to vessel source pollution. Vessel source pollution basically means pollution that has been caused by the shipping activities on the sea. This pollution most of the time involve the oil pollution. There are two types of vessel source pollution, namely operational pollution and accidental pollution. The operational pollution usually produced by normal and usual activities of the ships, and can be said as unavoidable. On the other hand, the vessel source pollution can also be caused by accidental pollution. It basically can be caused by accidents between vessels. There are also pollutions caused by disasters such as Torrey Canyon, Amadou Cadiz, Erika, and Prestige. In conclusion, there are two causes of pollution that affect marine and marine life. Whether it is accidental or operational, the effort to protect the sea from the pollution has to be continued.
Next, I will explain about liabilities of states. Due to marine pollution incidents, there must be a question regarding states' liabilities for the pollution damage right. Generally, Article 235 Clause 1 of the LOSC provides that contracting states are responsible for fulfilling their international obligation concerning protecting and preserving the marine environment. They share the liability in international law. While this is a significant move forward in creating state responsibility for ship contamination of the oceans, it does not include real penalty for states that do not fulfill this responsibility, nor does it serve to deter the convenient registry flag. Furthermore, Article 235 Clause 3 of the LOSC pointed out that as regards the implementations of current international law and the further development of international law relating to liability for the pollutions of the marine environments, states are required to comply entirely with the obligations to obtain reasonable and timely compensation for any damage caused by the contaminations of the marine environments. It is widely understood that the high seas are open to all states when addressing the duty of states concerning marine pollutions in the high seas. However, this right to liberty is still to be exercised under the conditions laid down in these conventions and other world international law. Hence, when marine pollution accidents occur in the high sea, the respective states can be held liable under specific law. This is important to protect the marine environments and the common interests among the conditions, even if the principle of the high seas freedom is applied. Next, move to the subtopics for liability of states, which is an international legal frameworks. According to the international law principle, the ships on the high seas are subject to the exclusive jurisdiction of the flag states. Furthermore, international law has been developed to make the flag states liable for environmental damage caused by their ships. Moreover, the international case law points out that the emergence of strict liability must be applied as a principle of public international law for environmental injury. One of the important cases is the case of Trail Smelter Arbitration, which is United States versus Canada, that has directly addressed state liability for extraterritorial environmental injury caused by a private concern within its territory. The trail smelter, located in British Columbia since 1906, was owned and operated by a Canadian corporation. The resulting effect of the sulfur dioxide from trail smelter resulted in the damage of Washington between 1925 and 1937. This led to United States filing a suit against Canada. The governments of the United States and Canada started a discussion of the matter in 1927, and in 1935 they entered into a convention for the establishment of a tribunal to resolve the dispute. In ruling on behalf of the United States, the court held that, under the rule of international law, no states have the rights to use or permits its territory in such a manner as to cause damage to or within the territory of another state. Besides, the tribunal held that in international law, the Dominion of Canada is responsible for the trail smelter conduct. As a result, for this case and other referred cases are establishing a consistent set of principles governing state responsibility for transnational environmental damage. This means that a state may not use its territory in such a manner which causes substantial damage to another state. In other words, a state shall be responsible for damage incurred by the actions of its instruments or by the activities of a private enterprise within its controls. As an addition, these principles not only apply to the cases that arose within the territory of the state in question, but also may be extended to apply to incidents which occurred outside the part of the defendant states, with the term that the wrongdoer is nonetheless subject to the defendant state's jurisdiction. States are free to grant nationality to ships, but the states cannot violate international law in applying their sovereignty. Further, a vessel on the high seas operates under nationality granted by the flag states, just like the copper plant in the trail smelter arbitration, which was operating under Canadian Charter. Therefore, it can be said that if a nation is liable for the conduct of a corporation operating within its border, a flag state should bear liability for actions of its vessels on the high seas, where the flag states have exclusive jurisdiction over the ships.
As we know, the Civil Liability Convention is silent regarding the marine pollution caused by vessels in the high seas. Besides, the principle that the flag states would be liable for damages to their ships' oceans also cannot solve this problem. Why? This is because the international law has prohibited the exercise of sovereignty over the high seas, and also because of the pollution on the high sea may not directly affect the interests of an individual state. Thus, an international body with authority to act against flag states for corruption by their ships must be recognized. However, how are we going to know who has the liability to settle this matter? This is where the doctrine of public trust comes into the picture, as the theory provides an acceptable legal justification for establishing such an authority to protect the oceans. The public trust doctrine recognizes that the state has held a specific defined property in trust for the public. Hence, the trustee has a high fiduciary duty of care and responsibility to the general public. Therefore, this clearly shows that the public trust doctrine would provide suitable protection on the high seas from the marine pollution caused by vessels. This is because a public trust approach would give a recognized trustee the right to act on behalf of the general public, since the high seas are not subject to ownership by individual claims. Henceforth, via this doctrine, if any problem regarding the marine pollution in high seas occurs, it can determine which state has the liability. However, how are we going to apply this doctrine? Actually, this doctrine provides the necessary legal underpinnings for international environmental law. So, by applying this doctrine, whenever pollution occurs in areas where individual states lack jurisdiction, or where they are not directly affected by the injury to the environment, this doctrine will determine an international trustee, who is someone who has the ability to act against the polluter. Part 11 of the Draft Convention on the Law of the Sea has mentioned the area of protection of the marine environment as a logical choice for an international public trustee. The Draft Convention acknowledged that claims of sovereignty over the high seas and the area are invalid. The invalidity of such claims precludes action by an individual state where the state interests do not have a direct impact. However, the Draft Convention also acknowledged that the area and its resources are the common heritage of mankind, where all rights in the heart of the area are vested in mankind as a whole. Hence, the authority shall act on behalf of the whole of humanity. Furthermore, the same convention states that the authority shall adopt rules, regulations, and procedures to protect and conserve of the area's natural resources and prevent the harm to the marine flora and fauna. Indeed, the implementation of the doctrine of public trust is an acceptable way of ensuring the marine environment security because the high seas and the area are not subject to exclusive ownership. This clearly shows that the application of the public trust doctrine is the right way to determine the liability of states regarding pollution caused by vessels in the high seas.
As conclusions, one of the pollutions in the high sea come from vessel. Those pollution will make many effects which are marine pollutions, hypoxia, and water quality. So we must take in steps to solve the problem. Therefore, more institutionalized processes are necessary to ensure compliance with treaties relating to marine environmental processes protections. These mechanisms merits highlighting in this regard started with foreign monitoring as the first one. Secondly, the authority of the port states and regulations of the port states. The third process includes by an international body, marine environmental protection. It is imperative to focus on the authority and power in the region to exercise regulatory and enforcement controls on climate security. An analysis of the authorities' practice offers valuable insights into the authorities' practice. Security of community interest by an international body concerning the protection of the marine environment. That's all from us. Thank you.